Pardon to make a mention, Lordship, BLAPL number 9885/2023. It was specifically adjourned to Lordship week commencing with 8/1/2023.
Pardon to mention, my lord, criminal
Correct,
appeal. I am convicted for RI for 10 years. He has already spent 8 years in custody.
My lord, in BLAPL number 10766 of 2023, the other co-accused person grant bail by this honorable court, and offense all are master tribal way mastered, my lord. And one revision application 33 of 2024, specific date adjourn, my lord, not listed.
Pardon to mention, my lord. Tired of bailment. Give it.
Criminal revision matter also directed to list the class. 2
Yes.
has been passed.
Yes. Pardon to mention, also the petitioner released on interim bail for a period of 1 month. And the date of surrender is 15/3/2024. And the petitioner wife condition is still give it.
Pardon, Lord, CRL number 138 of 2023, Lordship. Lordship, I have filed an interim application for stay of the order of conviction, Lordship. Another is for interim bail, Lordship.
Quickly list item number 1.
I have submitted the deposition copy of the victim girl to the State Council. Lordship may kindly have a glance to the deposition copy. In the cross-examination, she categorically stated before the court.
It's a case of conviction or
Lordship?
is it a case of conviction or?
Oh, bail, Your Lordship.
Okay.
That is what SC/ST Act. Since from
Note
2022.
is sufficient.
Yes, my lord, somebody is appearing. Vasudev Mahapatra. I am appearing in favor of the.
Okay. What is the date of custody?
Since from 2022, Your Lordship, from the date of affair.
Mr. Tripathi?
Yes, my lord.
What is the date of custody as per charge sheet?
Ekkoisi 2/23.
Affair 20/2/23, arrested on 21/2/23.
And what are the offences under which charge sheet submitted?
Yes, my lord. That is 376 2N 294
323, 417, 506, 31R, 31S, 31WI, 31W Roman 2, 32V, 32VA of SC/ST Act.
Where is the statement of the victim?
Statement of the victim reveals that there is a.
Have you not filed for the court?
Yes.
Where is that? That
I have submitted the
so-
certified copy, Your Lordship.
Suma Sabar is the victim.
Yes,
Yes, my lord. Two witnesses have been examined. One is the constable and the seizure witness. Another is the victim girl, Your Lordship. Certified copy I have submitted before this honorable court, and the copy, Xerox copy I have submitted before the State Council.
I have not received that.
You have not received?
No.
Yes.
No, you have not received the deposition copy of the victim.
No,
I have given the receipt is there.
you have filed there.
Yes.
Hand over the copy which is available with you. Deposition copy. Are you having the deposition?
Yes.
Pass on. Mr. Tripathi, please place
Yes.
that evidence. That is Suma Sabar.
Uma Sabar.
Yes.
I am the informant in the case. I know the accused person. The occurrence took place 2 years ago. The accused telephoned me from obtaining my phone number from my cousin brother. The accused telephoned me many times. I was working at Bhubaneswar. The accused telephoned me and told that he loved me, and if I will not develop love relation with him, he will cut his hand. After some days, I returned to my home from Bhubaneswar. I had gone to see the opera at village Dholpada, and the accused also came to see the opera at Dholpada. The accused came before me and said to sit on his bike. I sat on his bike and went towards Gohiri from jungle. The accused kept physical relationship forcefully in the jungle. I cried in the jungle, and he said that he will marry me and requested to stop my crying. Another day, we went to the jungle situated near the village of the accused. The accused kept physical relationship forcefully in the jungle, and the accused shoot my photograph in the jungle. I asked regarding the photograph, but the accused said that he will marry me. The accused telephoned me and threatened if I will not come before him, he will intimate the matter to my family and make viral my photographs. One day, the accused took me towards the house of his friend to the village Burbuda to marry me. He remained in the house of his friend.
We remained.
We remained in the house of his friend, and he kept physical relationship with me. In the next day morning, the accused told me that he will leave me in my house, and on the way, he assaulted me and also left me in the jungle. After that, the date of my marriage was fixed with another boy. The accused dissolved my marriage. After that, the accused told me to marry me as a registration marriage, but he deferred it many times. I lost FIR before Riamal police station. The FIR is marked as exhibit so and so.
Okay, please come to paragraph number 8.
Yes.
Cross examination.
Yes. We loved each other. We decided to marry by registration. I reached at a registration office, but the accused did not come to the registration office to marry me. We loved each other since 2020 and 2021. I have not recalled the phone number of my cousin brother, but his name is Rajesh Basantara. We talked by telephone to each other. the accused called me by phone, but I have not called him by phone. The accused had come to my village by bike.
And
And
come to next page, paragraph number 10, last sentence.
10. I wanted to compromise the matter, and I, along with volunteer of Sakhi Center, had gone to Niyamal police station to lodge a FIR. I have not seen my wearing apparels, which was seized by police. The accused telephoned me from the jail to meet, for which I had gone to jail to visit him 6 to 7 times.
What do you say?
My lords, my submission is the accused and the victim accused as forcefully
What
kept
type of force you are?
on their
You
claim.
accompanied her to jungle, she talking with her, love relationship. You are
After
going to the jail to meet her for 6 to 7 times
my lords,
and staying in the friend's house, keeping relationship.
my lords.
So what
After
force?
that-
You are a 22 years girl.
Nowadays, law were started between each
Are
other.
the land counsel for the petitioner, land counsel for the state, land counsel for the informant. Considering the submission made by the land counsel for the petitioner, that the petitioner is in judicial custody since 21 to 2023, and he has been charge sheeted under section so and so Lakidij. And after going through the evidence of the victim, who has been examined as PW2 placed by the land counsel for the state, I am inclined to release the appellant on bail. Allowed. Next.
Obliged.
Item 3.
Number 2 means acha delay bhi is there. Right. Non appears for the appellant. Defects as pointed out by the stamp reporter. Land counsel for the state submit that he has not received the copy of the appeal memo. Defects as pointed out by the stamp reporter shall be removed within a period of 1 week from today, failing which the CRL stand dismissed without further reference to the bench. Yes.
Item 5.
Item 5, my lord, I pray kindly taken up any other day, my lord.
May I please, my lord? Item number 5. Myself from DC at Sambal.
You are in which item? Item number 5. There are
Second
one.
Sub item, my lord.
Okay. What do you want, Mr. Mahanti?
I want to place my petition, my lord.
You want to place your matter. All right. You want adjournment.
My lord.
All right. You have received the case diary.
Case diary, yes.
Okay.
No, my lord. Case diary is another forum. So let it come tomorrow.
Tomorrow.
It is there.
All right. CRLA number 1182 of 2023. A mention is made on behalf of Mr. Manas Kumar Chand to adjourn the matter. It is adjourned. And what about the service of notice on the respondent number 2?
Notice served on 9/12.
All right. Next item, CRLA number 1226 of 2023. The London Council for the State submitted that notice on the informant.
No, the second item the notice survey. First item the survey. No, Bharat is
It's a connected matter, so
connected matter.
notice has been served on the
That's
connected
not-
matter, that is CRLA number 1182 of 2023, which is listed today since December 2023, non-appears for the respondent number 2. Learned counsel for the state submits that CD is attached to another file.
Yes, yes.
Case diary is attached to another file. The matter may be taken up tomorrow. Mr. Surendra Mahanti, learned counsel, appears to virtual High Court Sambalpur. Put up this matter tomorrow. Mr. Mahanti, it will be listed tomorrow. Okay?
Obliged. Obliged.
Item 6.
Mr. Mishra,
May I please?
who is appearing for the other side?
Notice was
Mr.
issued by
Pramod Kumar Pati. Not there. You have received the case diary? CRLA number 1222 of 2023.
ಇದವಾ?
Is it there, Mr. Tripathi?
CD is there.
Okay. Place your case.
The appellant was taken to custody on 12/10/2023, my lord.
Just a minute.
1298 তো?
हाँ हाँ
1298 নয়, এটা 1222.
1222 of
Yes,
CD available?
the CD is there.
Okay. So, what is the custody date, Mr. Mishra?
my lord, the appellant was taken to custody on 12/10/2023.
12/10/2023. Charge sheet submitted.
Yes, my lord. Charge sheet has been filed on 31/1/2024
What are the offenses?
under section 341,
Yes.
324,
Yeah.
326,
Hmm.
440, 307 and 34 of the Indian Penal Code.
Hmm.
Read with section 32V and section 32VA of the SC/ST Act.
So, is it the first application?
Yes,
or-
first application.
So, who is
And-
that NGO?
My lord, injured statement has been recorded.
No, what is
Injured-
the name of the NGO?
Yes, injured is Jitun Kumar Soren.
Huh?
Jitun Kumar Soren.
And what injuries he has sustained?
My lord, the statement is like this, my lord, of Jitun Kumar Soren. It was recorded on 19/10/2023. My lord, the statement read like this. मोर नाम जितुन कुमार सोरेन मु आज आपनको बयान देउ जे गत 8/10/23 रविवार संध्यारे मु खबर पाइली जे मु भल पाउथुबा समर्पिता ग्रामर बनिता दास सेई गाँर तळमुंडा करकु विवाह भोजी खाइबा पे जाई सेठार तार पूर्वतन प्रेमिक सौम्यरंजन बेहेरा सह कथा हेउची सौम्यरंजन बेहेरा आपेलेंट कथा हेउची बोली खबर पाई मु सेठारे जाई पहुंची देखिली बड़गुंडा घर पाखरे बनिता सौम्य सह कथा हेउची सेठी बनितार बड़ भौणी वर्षा एवं सौम्यर 3 जण सांग थिले मु बनिता को जाई रागिबारे बनिता सौम्य सांग ठारू मद ग्लास आनी पी देला रागरे मु सेई मद ग्लास फोपाड़ी देबारु सौम्य ओ तार 3 सांग सहित मोर झगड़ा लागिला या देखी नंदर भाई बीरमुंडा आमको अलगा करी सेठारु पठाई देला बनिता तार भौणी तांको घरको आसिले मु मध्य बाट पछ पछे आसिली प्राय 10टा पाखापाखि बनिता घर बाड़ डेई मु तांको बाड़ी रे पसिली एही समय कोन गोटे खसखस हैला मु भाबिली गोरु होइथिबो मु बुली पड़ी चाहिची कि नाही मो मुहरे पेट्रोल पड़िला मु हाथ मारिची मुहरे कोन बुली हठात निया लगाई देले निया आलोकरे मु मो सामनारे सौम्य ओ तांकर 3 सांग को देखि पारली सौम्य कहला निया लागिगला चाल पळेबा तापरे सेमाने सेठू बाड़ डेई पळेले मु आसीथिबा पटे बाड़टी नुआनिया थिला तापरे मु मरिगली पाटी करली बनिता और तार भौणी आसी पानी छाटी निया लिभाई मते नेई मोर माउसी घरे छाड़िले बाटरे मोर अधा पोड़ा सार्ट टी मु ओल्हाई देइथिली बनिता ସେଇଟିକୁ ସମର୍ପିତା ଛକରେ ରାସ୍ତା କଡ଼ରେ ଫିଙ୍ଗି ଦେଇଥିଲା। ମୋର ମୋବାଇଲଟି ମୁଁ ବନିତାର ବାରଣ୍ଡାରେ ଛାଡ଼ି ଆସିଥିଲି। ପ୍ରକାଶ ଥାଉ କି ମୁଁ ସୌମ୍ୟ ବେହେରା ଆଉ ତାର 3 ଜଣ ସାଙ୍ଗ ମିଶି ମତେ ପୂର୍ବ ଗଣ୍ଡଗୋଳ ପାଇଁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟ ରଖି ମୋ ଉପରେ ପେଟ୍ରୋଲ ଢାଳି ନିଆଁ ଲଗାଇ ଦେଇଛନ୍ତି। ଏଇ ବିଷୟରେ ଘଟଣା ଦିନ ରାତିରେ ମତେ ଡାକ୍ତରଖାନା ନେବା ସମୟରେ ମୁଁ ମୋର ବାପା ମା ମାଉସୀଙ୍କୁ କହିଥିଲି।
So this occurrence took place on 8/10/23.
My lord,
So he was hospitalized.
thereafter his statement was recorded on 1910.
And when he was discharged from the hospital.
That lordship may kindly.
And what are the
He has
injuries?
already been discharged.
What are the injuries sustained?
Injury report is might be available. And my lord. I don't-
30% burn injury.
Huh?
30% burn injury.
No, have you got the photographs of the
No,
victim?
Dying declaration is there.
No, it
Implement
becomes
yes.
clear that if the statement becomes that they threw.
Yes.
So you get that photograph, number one, and number two, if any criminal antecedent is there. Okay, so we'll take up next week. Mr. Arijit Mishra and Counsel place the statement of the injured Jitun Kumar Soren, from which it appears that he sustained burn injury due to overtime committed by the appellant and his friends on 8/10/2023. The statement has been recorded on 19/10/2023. Learned Counsel for the state, on verification of the case record, submits that
now he is inside custody, my lord, in another 395 case, my lord. That injured.
The injured has sustained 30% burn injury. Let the Learned Counsel for the state obtain the photographs of the affected parts of the victim, bracketary injured. So also instruction about the criminal antecedent, if any, against the appellant. Mr. Mishra, Learned Counsel for the appellant, submits that he has received instruction that the injured is involved in a case under section 395 of the Indian Penal Code, and he is now
Inside
in
custody.
judicial custody. Let the Learned Counsel for the state also obtain instruction in that respect. Free copy of the order be handed over to the Learned Counsel for the state. Of this matter is commencing from 18th March 2024.
Item 7.
Yes, Mr.
My lord, item 7, my lord, there is some minor defect. Today I
Copy
also
not served.
copy also right now some
5D means
No, no,
copy,
sir.
state copy not solved.
My lord.
So are you serving it
My lord,
today?
right now.
We are appearing for the informant. I pray for one of the
All
copy.
right. Learned Counsel for the appellant handed over the copy of the appeal memo along with the annexures.
Okay.
Annexure ଦେଇନାହାନ୍ତି? ନାଇଁ incomplete ଦିଅନ୍ତୁନି, ଆପଣ ଆଜି ଭିତରେ ସବୁ ଦିଅନ୍ତୁ।
କରିକି ଦଉଛି।
ଆଉ ରିଜେକ୍ସନ ଅର୍ଡରଟା ଦେବେନି। କ'ଣ ପାଇଁ ରିଜେକ୍ସନ ହେଇଛି କେମିତି ଜାଣିବେ? All right. Let the Learned Counsel for the appellant supply the appeal copy of the appeal memo along with the annexures, not only to the Learned Counsel for the state, but also to the Learned Counsel for the informant. The other defects, as pointed out by the stamp reporters, shall also be removed within 3 days. Put up this matter, the week commencing from 18th of. No, you are to receive that case diary, right?
No.
No. Upon anyway, so I'm granting you time. List this matter in the week commencing from 3 days नौकरी कर दियंतु by end of this week कर दियंतु, है ना? List this matter in the week commencing from 27th of March 2024. Case diary and instruction about the criminal antecedent, if any, be obtained in the meantime.
Okay.
Yes.
Item 8.
Item 8 not press.
Files and memos.
Item 9.
Yes.
Irmila,
All right, it will come next week on Monday.
My lord.
Item 14.
Yeah.
14 service of notice and CD not received.
Which police station? it is?
Borgad police station. It was sent on 6/3.
6-3. Okay. All right. The Learned Counsel for the state submits that notice has already been sent to so-and-so police station, IIC so-and-so police station for its service on the informant bracket respondent number 2, but he is yet to receive instruction regarding sufficiency of service of notice. Also the case diary put up this matter on 18th March 2024. CD and instruction regarding sufficiency of service of notice be obtained in the meantime. Yes.
Item 15.
May I plus ma'am. This is the
They are also the same.
Same means
CD and confirmation of notice.
କେବେ ପଠେଇଲେ?
এটা ପଠାଇଲା 19/2
ଏତେ ଦିନ ପର୍ଯ୍ୟନ୍ତ
ସରି 5/3
କୋଉ ଥାନା?
এটা ହଉଛି ଟିଗିରିଆ
Tigire.
Get it next week. 18/3/2024 CD and sufficiency of service of notice.
Item 16.
Yes, Mr. Mishra.
May I please, my lord?
Item 17.
May I please, your lord?
notice and CD report.
Notice sufficient ହେଇନି?
ନା।
Case diary ବି ଆସିନି?
ନା।
So
ଭଞ୍ଜନଗର
keep it on କୋଉ ଥାନା?
ଭଞ୍ଜନଗର
Right, 18/3/2024 CD and sufficiency of service of notice. Along with କରିଦେବେ, the second item will come. CRL number 134 of 20. Yes.
Item 18.
On last occasion, my lords, last order was to copy extra service, my lords.
You have served it.
My lords.
Notice sufficient.
yes 29/2/24
Okay, so there is some delay or what?
My lords, 72 days, my lords. We have filed an IA.
72 days delay.
lords.
It's a bail application.
Yes, my lords.
Huh?
Yes, my lords.
Okay. So, is it the first application or
My
already
lords,
first?
first.
So I'm condoning the delay, Mr. The Learned Counsel for the state submitted that notice on the informant has been made sufficient since
29/2.
29/2/24
29/2/2024. None appears for the informant. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 72 days in filing this criminal appeal. After going through the averments taken in the interim application, and since it's an application for bail, I'm inclined to condone the delay. Accordingly, delay is condoned. What is the date of custody?
Custody, my lords, 16/2/2023.
What are the offenses under which charge sheet submitted?
Offenses under IPC 302,
Yes.
201, and
302,
34.
201.
My lords,
Yes.
34. And SC/ST Act 3(2) of Clause 5, Clause V.
32B.
32V.
What is the name of the deceased?
Amar Machi.
Date of occurrence?
Occurrence, my lords, 15/2/23, my lords.
15/2/23.
My lords. FIR has been lodged on 15/2.
15/2
15/2. All right. So, is there any eyewitness to the occurrence?
No, my lords.
No
7 witnesses has been examined. No
In
one
the-
had
in-
said
in-
any
in the
single
trial court?
My lords. No one said any single word about the petitioner.
No, I just want to know that whether there is any eyewitness to the occurrence or not.
No, my lords.
No.
No.
So, what are the circumstantial evidence against the petitioner?
Informant only said about the event when he heard about from the villagers.
No, what is the total circumstantial evidence, extrajudicial confession, leading to discovery, like this last scene? So, if eyewitnesses are not there, then what are they are against you? What are the materials against you?
Material informant only said about my name in the FIR.
कौन अच्छी कहले?
confessional statement before police
Okay.
leading to discovery of the weapon, and query report also supported that
Leading to discovery of what?
weapon.
What was seized? What is that weapon?
ଜାଳ କାଠ।
Hmm.
ଏଥିରେ ପିଟି ହତ୍ୟା କରିଥିଲେ।
So no eyewitness.
No.
Any extrajudicial confession, last scene, dying declaration?
Statement of the informant will
Informant किए? ना कौन?
मोतीलाल माची। Married.
How the informant is related to the deceased? Yes.
Brother, my lords.
भाई.
Yes, my lords.
All right. Brother of the deceased.
My lords.
हाँ कौन है ला पढ़ो
Yes.
तुको?
15/2/23 ତାରିଖ ଆମ ସକାଳେ ଆମ ଗ୍ରାମର ରାଜେଶ ମାଝୀ, ରଶ୍ମିତା ମାଝୀ, ମହାଦେବ ଘଡେଇ ଆମ ଘରକୁ ଆସି ମୋ ସ୍ତ୍ରୀକୁ ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରି କହିଲେ, ତୋ ସ୍ୱାମୀ ଗୁଣି ଗାରିଡି କରି ପାଙ୍ଗୁଛି, ତୋ ସ୍ୱାମୀକୁ ଓ ତା ଭାଇକୁ ମାରିଦଉ।
Mahadev Ghade means this appellant,
Yes.
along with others. Okay, then what happened?
ଆଉ ଭାଇକୁ ମାରିଦଉ। ରାଜେଶ ଧରିଥିବା ଟାଙ୍ଗିଆରେ ଆମ ଘରର ଦୁଆର ବାଡାକୁ କୁଟାକୁଟି କରି ମୋର କନ୍ୟାକୁ 2-3 ଟଣ୍ଟିଆ ମାରିଲା। ମହାଦେବ ଗାଳି କରି କହିଲା, କନ୍ଧ ସ୍ଲାଙ୍ଗ, ମୋର ଝିଅକୁ ପାଙ୍ଗୁଛ, ଆଜି ସବୁକୁ ମାରିଦବୁ। ତୋର ସ୍ୱାମୀ ଆଉ ତା ଭାଇକୁ ମାରିଦେବୁ। ମୁଁ କାମ ପାଇଁ ସକାଳ 8:30ଟାରେ ଘରୁ ବାହାରି ଯାଇଥିଲି। ଜଳେଶ୍ୱର ମନ୍ଦିର ନିକଟରେ ମିସ୍ତ୍ରୀ କାମ କରୁଥିଲି। ମୋ ସ୍ତ୍ରୀ ମତେ ଫୋନ କରି ସବୁ କଥା ଜଣେଇଲା। କହିଲା ତମେ କାମରୁ ପଳେଇ ଆସ, ସେମାନେ ଏଠି ଗଣ୍ଡଗୋଳ କରୁଛନ୍ତି। ଏହାପରେ ମୁଁ ମହାଦେବ ଘଡ଼େଇକୁ ଫୋନ କରି ପଚାରିବାରୁ ସେ ମତେ ଗାଳି ଗୁଲଜ କରି କହିଲା, ତୁ ମୋର ଝିଅକୁ ଗୁଣି କରି ଟାଙ୍ଗୁଛୁ, ତତେ ଆଉ ତୋ ଭାଇକୁ ମାରିଦେବୁ। ମୁଁ ତାକୁ କହିଲି, ତମେ ଯଦି ଏତେ ବିଶ୍ୱାସ କରୁଛ ମୁଁ ତମ ଝିଅକୁ ଗୁଣି କରୁଛି ବୋଲି, ତମେ ବେକାର କଥା କାହିଁ କହୁଛ? 5 ଜଣ ଭଦ୍ରଲୋକ, ସରପଞ୍ଚ ଓ ଥାନାକୁ ପୋଲିସକୁ ଡାକି କଥାବାର୍ତ୍ତା କର, ସମାଧାନ କର। ମୋ ନାଁରେ ନହେଲେ ମୋ ନାଁରେ କେସ୍ କର। ମହାଦେବ ହଠାତ୍ ରାଗି ଯାଇ କହିଲା, ସମାଧାନ କିଛି ନାହିଁ, ତତେ ମାରିଦେବୁ। ତୁ ଗୋଟେ କିଏ? ପୋଲିସ କିଏ? ଥାନା ଜଣାନେ ଆମକୁ ଦେଖଉଛୁ, ଆମେ କଣ କରିବୁ? ମୁଁ ମହାଦେବକୁ କେନ ଅଛ ବୋଲି ପଚାରିବାରୁ ସେ କହିଲା କି ପେଙ୍ଗସୁର ମନ୍ଦିର ପଡ଼ାରେ ଅଛି। ସେତେବେଳେ ମୋର ଭାଇ ଅମର ପାଟି ଶୁଣି ମୁଁ ମହାଦେବ ତା ସହିତ ଝଗଡ଼ା କର ନାହିଁ, 5 ଜଣ ବସି ସମାଧାନ କଲେ ହେବ ନାହିଁ କି? ସେ ରାଗି ଯାଇ କହୁଥାଏ, ରାଜେଶ କହୁଥାଏ, ସ୍ଲାଙ୍ଗ ଏମାନେ ମୋର ପୁରୁଣା ଶତ୍ରୁ, ମତେ ମାରି ମୋ ପଞ୍ଜରା ହାଡ଼ ଭାଙ୍ଗିଥିଲେ, ମାର ମାର ପଲାରେ ମାର। ମୁଁ ଭୟରେ ଫୋନ କାଟିଦେଲି। ସଙ୍ଗେ ସଙ୍ଗେ ଥାନାକୁ ଯାଇ ଏଇ ଲିଖିତ ରିପୋର୍ଟ ଦେଲି। ପୋଲିସ ଆଜ୍ଞାମାନଙ୍କୁ ଗାଁକୁ ଦେଖିଲେ ମୋ ଭାଇ ମନ୍ଦିର ପାଖରେ ମରି ପଡ଼ିଥିଲା।
So this informant,
Yes,
Motilal Majhi,
yes.
he is one of the material witness. Has he
Material.
been examined in the trial court?
Yes.
You said 7 witnesses have been examined
Yes, my lords.
and they have not stated anything against you.
Yes, my lord. PW1.
What he has stated?
I know the accused person training the dog. I am the informant in the case. Deceased was my brother. On 15/2/23, the occurrence took place. I had left for work. Accused Rajesh Majhi along with his wife Rasmita Majhi came to our house being armed with axe. Then told my wife that your husband was practicing black magic, witchcraft, and searched for me. The accused Rajesh threatened to kill me, and as I was not there, he destroyed the boundary fence of by axe. Though my wife tried to convince them that no such practice was done by me, they accepted her. Then they left the spot and went towards Mandirapoda of our village. Found me about Rajesh Maji, Mahadev Ghodai to settle the matter. And at the time, I heard that they were shouting to kill the deceased. So, out of fear, I went to PS and lost the affair.
No, the initially 2 persons came
Yes.
to the house of this informant.
Yes.
But this, as it appears, this Mahadev was not present
No. At the time of
initially.
initial.
Then he telephoned to that Mahadev, that means the appellant. There she came to know about that some kind of holla he was doing.
Yes.
And what about the criminal antecedents?
No instruction, my lords. I would know.
That has not come.
Are the learned counsel for the এটা delay condone for next main number. Learned counsel for the appellant submits that the appellant Mahadev alias Mahadev Bhadi is in judicial custody since 16/2/2023 and he has been charge sheeted under section 302(201)/34 of the Indian Penal Code and section 32 small v of the SC/ST PO Act. The occurrence in question took place on 15/2/2023 and the first information report was lodged on the next day, that is on 16/2/2023 by Motilal Majhi, who is the brother of the deceased Amar Majhi, and there are no eyewitnesses to the occurrence. Land Council further submits that in the meantime, trial has commenced and 7 witnesses have been examined. And there is no clinching evidence against the appellant, and therefore the bail application of the appellant may be favorably considered. Learned counsel for the state placed the evidence of the informant Motilal Bajhi, who has been examined as PW1 in the trial court. He also submitted that at the instance of the appellant, one split wood was recovered on the basis of the statement recorded under Section 27 of the Evidence Act. From the statement of PW1, it appears that at the initial stage when the accused persons visited the house of the informant and gave threat to kill the deceased, the appellant was not present with them. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced so far in the trial court, period of detention of the petitioner in judicial custody, I'm inclined to release the petitioner appellant on bail subject to condition that he shall appear before the learned trial court on each date be posted for trial and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed. Attorney.
May I request one thing, my lords? Pardon, my lords. My name to be mentioned, my lords.
What is your name?
A Panda, Ankan Panda.
Huh?
A Pandal.
Hey, sleep Nada Pura Nada.
Deeply.
Yes.
Item 19.
notice, CDCA, and confirmation letter. Yes.
Item number 21.
Permitted to withdraw this application. Withdraw.
Challenge the order of confiscation proceeding of vehicle, Bolero vehicle, OR02 AZ 9988. Judgment dated 28/2015. Another case is CRLA 447 of 2015, tagged in this case. The accused person Lalit Kumar Jadhav. Your Lordship has period undergone release on bail on 2.
No, the London trial court has held the accused guilty. Not that it's a case of acquittal. So you are an accused in that case.
No.
So you are the owner of that vehicle in which the. So what has happened?
Driver of the vehicle has been.
Okay, driver of vehicle faced trial and he has been convicted. So how do you say that that was not within your knowledge?
No knowledge. The vehicle has transported, but the vehicle.
You see, once the NDP sector. The appellant was, the accused was also convicted.
Type of seizure of goods.
No. The accused was convicted under section 20B2C and sentenced to RI for 10 years. And so also under section 47A of Bihar and Orissa Excise Act, and RI is for 3 years, right? So you are not an accused in the case. You are the driver of the offending vehicle in which the contraband ganja of commercial quantity and other things are being carried out. So now you come to the and what he has ordered in the operative part of the.
Page 30.
Yes.
Page 30, last part 26 in the middle. The Jimano in respect of seized documents of Bolero vehicle bearing registration numbers 402 AZ 9988 of such as RC book, smart card, RC permit, and insurance certificate with her in Jima of owner of the vehicle, Badrinath Mission, the present appellant.
Yeah.
Be cancelled, and the Jimano in respect of the receipt SR sections SP, which is Jima, Puspanjali Saha, extend of the SP cancelled. And after expiry of appeal period, case of no appeal.
So in 2015, an order was passed that you have taken the vehicle in Jima, right? Right. So that was cancelled and direction was given that is there any order of stay?
Manner on dictate to
Because once the judgment, the next step he has to take is for confiscation.
5/10/2015. vehicle in question may not be confiscated pending finals of the appeal.
No, that's all right. That's a interim order was passed.
My lord,
Now come to the provision of the confiscation.
section 45.
Come to the NDPS Act, 20B2C of the NDPS Act,
My lord,
and the confiscation, it starts from section 60 onwards.
section 60. Section 60, liability of illicit drugs, substance and plants, articles and conveyance of confiscation.
Yes.
Whenever any offense punishable under section this act has been committed, the narcotic drugs, physical substance, controlled substance, opium, poppy,
Hookah
cocaine,
plants.
cannabis, plant materials, apparatus, and utensils in respect of which or by means of which such offense has been committed shall be liable to confiscations.
Hmm.
Any narcotic drugs or physical substance or controls of lawfully proceed imported interstate, exported interstate, imported into India, transported manufacturing poses
Leave it to come to Roman that 3, subsection 3 of section 16.
3, any animal or conveyance used in carrying any narcotic drugs
So
or
it is a case of conveyance, yes. Any conveyance used in carrying any narcotic
proceeding
drugs
making
or psychotropic substance or so and so, or any article liable to confiscation
confiscation
under
of
subsection 1 or subsection 2 shall be liable to confiscation unless, this is most important, unless the owner of the animal or
owner
conveyance
conveyance
proves that it was so used without the knowledge or connivance
proves
of
that
the owner himself and his agent, and if any, the person in charge of the animal or conveyance,
that each of
and
them
that each of them had taken all
all
reasonable precautions against such use.
such case.
So, if you can prove to the satisfaction of the court that your vehicle was used without your knowledge for
No, no.
such purpose, that means the transportation of
Conflict.
ganja was without your knowledge and it was without the connivance of the owner, and that you had taken all reasonable precautions against such use. In that case, only the confiscation
liable to be confiscation.
may not be done. Otherwise, then next is come to pay 63.
Procedure in making confiscation. In the trial of offense under this act, whether the accused is convicted or acquitted or discharged, the court shall decide whether any article or thing seized under this act is liable to confiscation under section 60 or 61 of or 62, and if it decides that the article is so liable, it may order confiscation accordingly. Where any article or thing seized under this act appears to be liable to confiscation under section 60, 61, 62, but the person who committed the offense in connection therewith is not or cannot be found, the court may inquire into and decide such liability and may order confiscation accordingly.
Then next is most important.
Provided that no order confiscation or confiscation of an article or thing shall be made until the expiry of 1 month from the date of seizure, or without hearing any person who may claim any right thereto, the evidence and the evidence, if any, which he produced in respect of his claim.
So
Provided.
that means an opportunity of hearing is to be given to you.
Ma'am.
So where is the judgment has simply mentioned that the Jimanama which was with you, the Jimanama of the Bolero vehicle which was with you was cancelled. So that is not making it that the confiscation proceeding has been initiated. Okay, because thereafter the next step has to be taken is for confiscation. The vehicle would come to the possession of the authorities, then the confiscation proceeding will start. Obviously, notice will be given, and in the notice you will be asked to file your show cause, and if you can satisfy the authority that it was used without your knowledge, without your connivance, and that you had taken all reasonable precautions against such use, then can only the confiscation will not be made. Otherwise, it will be liable for confiscation. So here is a case where is the material before this court that after the judgment was pronounced, after this Jimanama was cancelled, any confiscation proceeding was initiated. Because unless the confiscation proceeding is initiated, you will have you are the giving you chance or opportunity does not arise. And this court cannot decide at this stage because you have not placed your cards before the authority concerned. The authority concerned must initiate a proceeding for confiscation. Notice has to be issued. You will have your say before the authority. Okay, and then if your case will come within this purview that it was without your knowledge, without your connivance, and you have taken reasonable precautions, that grounds will be taken, and you may adduce also evidence to that effect. And if the authority is satisfied, then the vehicle may not be confiscated and it will be released in your favor, even though the accused persons have been found guilty and their appeal is sub judice. So now please show that where is the confiscation, what is the confiscation case number?
Case number.
Whether have you made any averment at all that any confiscation proceeding so far as the vehicle is concerned has been initiated? So if not, then wait for the appropriate stage. Let the confiscation proceeding be initiated. Let the notice be issued. Then the follow-up action will go. You will be given an opportunity. Why you have come at an early stage, a premature stage? It is only simply that the Jimanama has been cancelled. This criminal appeal has been filed under section 454 of CRPC, challenging the judgment and order dated 28/2015 passed by the London First Additional Session Judge cum Special Judge under NDPS Act Khurda in TR case number 34/14 of 2011. In directing that in directing as follows, Karjun, in directing as follows, in operative portion paragraph 26 of quote kar diyantu. The learned counsel for the petitioner submits that the petitioner was not an accused in the said case. One Lalit Kumar Jagdev faced trial under section 20B2C of the NDPS Act and section 47A of the Bihar and Orissa Excise Act. And he was found guilty of the offences charged and accordingly sentenced to substantive imprisonment, so also imprisonment for us also. And in the operative portion, the Learned Trial Court has observed as follows. Quote the entire paragraph number 26. The Learned Counsel for the appellant submits that the Learned Trial Court, while convicting the accused, has held that the seized Bolero vehicle bearing registration number so and so be confiscated to the state. The Jimanama in respect of, no, that is not the inter alia kar diyantu, be confiscated to the state. And the Jimanama in respect of the seized documents of the Bolero vehicle bearing registration number so and so, such as RC book, smart card, RC permit, insurance certificate, which were in the Jima of the petitioner who was the owner of the vehicle, cancelled. The Learned Trial Court, the Learned Counsel for the petitioner drew the attention of this court to the provision under section 60 and 63 of the NDPS Act. Which are quoted in here in below. The combined reading of these two sections indicates that the owner of the offending vehicle has got a valuable right in opposing the confiscation, and if he satisfies the court that the vehicle was used without his knowledge or connivance, and that he had taken all reasonable precaution against such use, comma, even though the vehicle might have been used for carrying contraband article, comma, the same may not be confiscated. To the state. Similarly, whether the accused is convicted or acquitted or discharged, in the trial of the offenses under NDPS Act, the court has to decide whether the vehicle is liable for confiscation or not. It is more clear from the proviso to subsection 2 of section 63 that an order of confiscation of a vehicle cannot be made without hearing the person who might claim any right thereto and the evidence, if any, which he produces in respect of his claim. From the impugned judgment and operative part in paragraph number 26, it appears that no opportunity of hearing has been provided to the appellant to have his say, and after convicting the accused, the London trial court straightaway held that the seized Bolero vehicle is to be confiscated to the state, and the Jimanama in respect of the seized documents of the Bolero vehicle. So also, nay, to be cancelled. This was not in consonance with the provision as enumerated above. Therefore, in paragraph number 26 of the impugned judgment, after hearing the London counsel for the state, in paragraph number 26 of the impugned judgment, where the London trial court has held the Bolero vehicle, seized Bolero vehicles to be confiscated to the state, and cancelled the the confiscated to the state is hereby set aside. The appellant shall produce the vehicle before the authority in question who has made the seizure, along with the documents which he has seized, documents the authority has seized from his possession within a period of 2 weeks from today. And the confiscation proceedings shall be initiated thereafter, and opportunity of hearing has to be provided to the appellant to have his say in the matter. And the court has to decide whether the vehicle is to be confiscated or not. If the confiscation proceeding is not initiated within 2 weeks from the date on which the vehicle and its documents are handed over to the concerned authority, comma, no further confiscation proceeding can be initiated in as much as the impugned judgment was passed on 28/2015. However, if confiscation proceeding is initiated, then within a period of 3 months from the date on which the appellant enters appearance, the same shall be disposed of in accordance with law. It is made clear that this court has not expressed any opinion about the merits of the confiscation proceeding, which may be initiated in connection with the offending vehicle. Accordingly, the criminal appeal is allowed. The copy of the order be communicated to the learned trial court for compliance. Yes, next.
Item 23.
Draft yes.
May I please, Your Lordship? Appellant convicted for offense under section 20B2C of the NDPS Act and sentence for 11 years and a fine of 1 lakh rupees. My lord. Last occasion, Your Lordship has directed to get custody certificate, my lord, because he is in custody since 4/12/2014, my lord.
Yes, what is your instruction?
Already in custody for 9 years, 2 months.
What is the sentence imposed?
11 years.
11 years. Fine of 1 lakh.
20B2C.
My lord.
All right. Heard the learned counsel for the.
May not be here.
You have not verified it.
Earlier verified, my
Verified.
Verified means he was granted interim bail.
lord. Interim back, but he has not released, my lord.
Okay.
That time it was very bad.
So let the exercise be done by the learned trial court. Okay. IA number so and so. This is an application for bail. The learned counsel for the appellant submitted that the appellant is in judicial custody for more than 9 years. Out of 11 years of substantive sentence imposed by the learned trial court. And even though the paper book has already been prepared, but there is no chance of early hearing, and therefore the appellant may be granted bail. Learned counsel for the state has produced the custody certificate of the appellant from Senior Superintendent Circle Jail Cuttack at Chaudhar, which reveals, it is dated, date kahin hai yaar?
29/2/2020.
Who did you date aaj?
আমার enclosure copy there আছে.
Which, according to the learned counsel for the state, is 29/2/2024. Also signed ta korchi ta thora dekha joni clearly. All right. Considering the submission made by the learned counsel for the respective parties, the sentence imposed by the learned trial court, the period already undergone by the appellant in judicial custody, and keeping in view the ratio laid down in the case of Muhammad Muslim, I am inclined to release the petitioner on bail. subject to condition that before accepting the bail bond, the London Trial Court shall verify through the Superintendent of Police Cuttack whether the address furnished in the cost title of the appeal memo is correct or not, since the petitioner is a man from district is stated to be a man from district Lakhisarai, Sarai, in the state of Bihar. And the London Trial Court shall impose inter alia the two local sureties as for the grant of bail uh, for for filing the bail bonds. Yes,
paper book ready.
paper book is ready, all right, but come next.
Obliged.
Item 24.
Please, your lordship, my lords. Look, this is a case of conviction under 20B2C of the NDPS Act. I have been convicted for array of 12 years and a fine of 1 lakh. I have filed an application for bail. On the last occasion, your lordship was pleased to call for the custody certificate on the submissions that he has already undergone half of the sentence.
What is your instruction?
I have given it. Already in custody for more than 6 years.
6 years, 3 months, 6 days.
Right.
What is the sentence imposed?
Look,
20B2.
20B2C
No,
for
no,
12
what is the
years.
sentence?
12 years.
12
12
years.
years.
Internal page 20, my lords, of the judgment.
Is a local man.
My lords, honorable.
All right. Heard the London Council for the petitioner and counsel for the state. Considering the submission made by the London Council for the petitioner that out of 12 years of substantive sentence imposed by the London Trial Court, the petitioner has already undergone more than 6 years of sentence. And case is not ready for hearing. And after going through the custody certificate produced by the London Council for the state, custody certificate of the petitioner produced by from Superintendent Juvenile Jail Angul. This man was a juvenile.
Lords,
What is juvenile jail mean?
no.
No. Superintendent Juvenile Jail Angul, which indicate dated our date ke there 7/3/2024, which indicate that he has already undergone 6 years, 3 months of sentence. And keeping in view the ratio laid down in Mohammed Muslim case, bail is allowed.
Grateful, my lords.
Yes.
Item 25.
And your lordship, my lord, here, my lord, 10 years conviction for commission offense
Item 26.
May I please, Your Worship, my lord, this is a case under section 22B2C, RI for 15 years. Benefit under section 32B is claimed, and my lord has asked me to give another bailer whose name is Abhinav Gowda of Rishipur. So I have given the address for document verification.
This bail application is for both the appellants or
The one, Nandan.
Nandan Ram means appellant number one.
One.
So he is an outsider.
Yes, ma'am.
So the address verification has been made. Mr. Tripathi is a man from Bihar. So whether you have made the address verification, and he stated that he has given you the deposition, the documents of two local sureties.
Let it come on Wednesday. I have not.
Wednesday. All right.
Thursday, my lord.
All right. So address verification number 2 about what documents he has furnished about the two local sureties, whether that has been verified or not. All right. Land Council for the state submitted that the matter may be taken up on 14th of March 2024. To verify the records whether the address verification of the appellant number 1, Nandaram alias Karan, has been made or not, and similarly whether the documents of the two local sureties have been verified or not. Put up this matter on such and such date, 14 tarikh, 14/3/2024. Yes.
Item 27.
May I please, Your Lordship? My bail application was earlier rejected.
Item 28.
May I please, Your Lordship?
Yes, sir.
Last date custody certificate was called for. He was sentenced for 15 years for the offence under section 20B2C.
So what is the sentence?
15 years, my lord.
No. What sentence he has undergone?
6 years, 2 months. And the
Why
co-accused
15 year sentence was imposed? Keep that 32B was taken into account or not? It is a offence under 20B2C.
20B2C, yes.
So, Mr. Tripathi, the main ground for imposing this 15-year sentence is that the quantity is 171 kg of ganja and it was found at a public place. And it was obviously for the purpose of sale. That is the finding. But what is that NDPS Act? So 32B says factors to be taken into account for imposing higher than the minimum punishment. So minimum punishment 20B2C is 10 years. So it has to be taken into account the use or threat of use of violence or arms by the offender, the fact that the offender holds public office, this is not applicable. Fact that the minors are affected by the offense, not applicable. The fact that the offense is committed in an educational institution, not applicable. Fact that the offender belong to organized so and so, no material. Offender is involved in so and so in other illegal activities, so no material. So how do you sustain a 15 years sentence unless so if it comes down to 10 years, then he has undergone 6 years of sentence. What is that age? Kete period
Well,
ta kete?
5 years, 10 months.
No.
কেবেকার এটা কস্টডি সার্টিফিকেট
5
5/3/2024 and it is mentioned as 5 years 10 months 7 days, right? And he is a man from
Odisha, my lord. Local man. He is from Gajpati, Mohana Gajpati.
CRLA, Mohana Gajpati. All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner Dilip Kumar Adhikari has been sentenced to RI for 15 years and to pay fine of rupees 1,50,000 in default to undergo further RI for 2 years each for the offense under section 20B2C of the NDPS Act. He submits that while imposing the substantive sentence of 15 years, comma, the learned trial court has not taken into account the provision under section 32B of the NDPS Act, which indicates what are the factors to be taken into account for imposing a punishment higher than the minimum term of imprisonment. The Land Council submits that in view of the impugned judgment, in the finding of the impugned judgment, the Learned Trial Court could have sentenced the petitioner for maximum period of 10 years. And the petitioner has already undergone half of the substantive sentence of that 10 years, and is a local man, and there is no chance of his absconding, and therefore the bail application may be favorably considered. Learned Counsel for the sufferer state has produced the custody certificate dated 5/3/2024 of Senior Superintendent Circle Jail Barhampur, from which it reveals that the petitioner has undergone 5 years, 10 months, and 7 days of sentence. The custody certificate is taken on record. Considering the submission made by the Learned Counsel for the respective parties, keeping in view the provision under section 32B of the NDPS Act, and the period already undergone by the petitioner in judicial custody, and also keeping in view the ratio laid down in case of Muhammad Muslim, bail application is allowed. Oh, please.
Item 29.
May I
Item 30.
May I please, Your Lordship? My lord, it's an application for bail, Your Lordship. He has surrendered in the meantime. The last occasion, Your Lordship granted bail, and he surrendered in the meantime.
When he was granted interim bail?
My lord, 3 occasions he was granted interim bail.
Last time I'm asking.
Last time he was, Your Lordship kindly looks at order dated 30/10/2023, my lord.
For what period he was granted interim?
3 months.
3 months.
Yes, Your Lordship.
Now you have surrendered.
Yes, Your Lordship. That
But
is flag G. If Your Lordship kindly looks at flag G, the surrender certificate is there, madam. I filed it with a memo, my lord. I filed it with a memo.
Flag G.
Yes, Your Lordship. That is in the noting.
No, that is dated 5/9/23.
No, it is. It is 26/2/24, Your Lordship, which is in the noting itself.
26 ନା 12/2/2024?
12/2 ରେ surrender କରିଛନ୍ତି। ମୁଁ ମେମୋଟା ଦେଇଛି 26/2/24।
ହଁ ଠିକ ଅଛି 12/2 ରେ ଆପଣ surrender କଲେ।
My lord, yes, Your Lordship.
So now what do you want?
Further bail, my lord, because the paperwork is not prepared yet, and his conduct is good. 3 times he was granted bail, and he has surrendered in the within the stipulated period, my lord.
So ଆପଣ ଆଣିଛନ୍ତି ତା ଦେହରେ ଯୋଉ ଯାଇଥିଲା କିଛି ଗଣ୍ଡଗୋଳ କିଛି କରିଛି କି ନାହିଁ? So take that instruction. The IA number so and so. This is an application for bail. Learned counsel for the petitioner submits that thrice the petitioner has been granted interim bail, and on each occasion after availing the interim bail period, he has surrendered at right time and he has never misutilized his liberty. Learned counsel for the state seeks some time to obtain instruction from the concerned IAC about whether the petitioner has misutilized his liberty or not. A report be called for from the learned trial court to the effect whether the appellant surrendered after availing the interim bail period at right time or not. Put up this matter in the commencing. That report should reach on or before such and such date. File be placed before register judicial. Matter be listed on 27th of March 2024. Yes.
Obligors.
Item 31.
Yes, Mr. Patnaik.
My lord, defect removed within 1 week.
5D means state copy. You have not received the copy.
I have received the copy.
Received it.
Judgment copy ଟା ଦେଇନାହାନ୍ତି।
Oh, judgment copy ଦେଇନାହାନ୍ତି। ଖାଲି appeal memo ଦେଇଛୁ। And what about 4A? अच्छा 4A ଟା ହଉଛି 6.60 authentication fee payment କରିବେ। ବୁଝିପାରିଲେ?
Yes, my lord.
ତାଙ୍କୁ appeal memo ଦେଇଛନ୍ତି without judgment, that you also complied. The learned counsel for the appellant undertakes to remove the defects as pointed out by the stamp reporter within a week.
Yes, my lord.
Within a week. Put up this matter immediately after the defects are removed. Yes.
Right.
Item 32.
May I please, ma'am?
Okay, prisoner's petition has come wherein he seeks permission for withdrawal of the CRLA and to continue the JCRLA. So you are appearing in JCRLA or CRLA?
JCRL.
JCRLA. All right. CRLA number 646 of 2020. Hello? Here is the prisoner's petition in which prayer has been made for withdrawal of CRLA and to continue JCRLA. Prayer made is accepted, CRLA is disposed of. Now, JCRLA number 92 of so and so. Have you filed any application?
Yes, madam.
Who had application?
Wakalatnama.
Wakalatnama
Miss application.
all right. JCRL number so and so. So the name of Babita Sahu will remain. Kaha na rahibo kundu.
Bobita Sahu,
Pavitra Moh Kumar Datta.
Pavitra Kumar.
Ei dita na rahibo. All right. Mrs. Babita Sahu and Pavitra Kumar Datta name will remain the name
Miss Bobita Sahu.
of
Miss Bobita Sahu.
Miss Babita Sahu and Pavitra Kumar Datta shall remain. Name of Chandan Mishra will be reflected in the cause list henceforth. All right? Yes.
Item 33.
33, Bini Mishra. Yes, Behra.
Last occasion, let's see. Only take instruction.
Item 34.
Yes, Mr. Panda.
Lords, here the state had been asked to take instructions with regard to the element of the appellant
Number 130.
and on IA 133 of 2020.
Yes, present health condition of the petitioner from the concerned jail superintendent. What has happened? What is the
He is suffering from oral cancer. And your lordship has released him on interim bail.
when?
Paragraph 4 of the IA, my lords may see, on 8/8/2022, your lordship granted bail in IA 1173 of 2022 for 2 weeks. Again on 12/9/2022 for 2 months. 14/11/2022 for 10 weeks. 11/4/2023 for 2 months. And 18/7/2023 for 2 months. 17/10/2023 for 2 months. I have given the details at paragraph 4 of the IA.
So it is that his condition is deteriorating day by day.
Yes, Lord. But hyper.
Praise complaint of blood in stool, unable to sleep, difficulty in digestion, so on, so on. Primary treatment given at our level. Patient have to urgent need of hospitalization, supervised treatment at cancer hospital. Aguru Kethar Jaichi. Are the Learned Counsel for the petitioner, Learned Counsel for the state. Mr. Devasis Panda, Learned Counsel for the petitioner, submits that earlier this court has granted interim bail to the petitioner, mainly on the ground of his ailment. And after availing the same, he surrendered at right time. Now the health condition of the petitioner is deteriorating day by day on account of oral cancer, and he immediately needs hospitalization in cancer hospital. And therefore, he may be granted bail. Learned Counsel for the state has produced the health condition report of the petitioner from Superintendent Subjail Nimapada, in which the report furnished by the medical officer CHC Nimapada dated 16/2/2024 has been annexed, which indicates that the petitioner's physical and mental condition is deteriorating day by day, and the petitioner has phrase complaint of blood in stool, unable to sleep, difficulties in digestion, nausea, and headache, and primary treatment was given. But the petitioner needs urgent need, and there is urgent need of hospitalization and supervised treatment at tertiary care center cancer hospital. Stop. The medical documents filed by the Land Council for the state is taken on record. The Land Council for the state has also produced the instruction about the criminal antecedent respect of the petitioner dated 6/3/2024 received from officer in charge of Balanga police station, which is taken on record. Considering the submission made by the learned counsel for the respective parties, these are all old cases.
Yes,
Considering the submission made by the learned counsel for the respective parties, the health condition report furnished by the learned counsel for the state, and since there is absence of any material that while on interim bail as per the order of this court granted in this CRLA, the petitioner has misutilized his liberty. I'm inclined to release the petitioner on bail allowed.
May I pray for an urgent settlement?
Yes, sir.
Item 35.
My lord, item 35 and 36
Yes.
Item 38.
It please your lordship. I appear before your lordship on behalf of S.K.SAHOO, sir. Call the matter a week after. Call the matter.
So are you aware about the defects which has been pointed out by the stamp
No,
reporter?
I don't.
So please go through it and try to remove the defects.
Okay.
There is delay, all these things are there. Go through, hand over the file to him so that he, yes, the learned counsel appearing for the appellant seeks some time to remove the defects as pointed out by the stamp reporter. Mr. J.P. Patra, learned special counsel for the state of Orissa in OPID Act matter is present. Put up this matter immediately after the defects are removed. Yes.
Item 39. Item 41.
One kindly taken up 2 weeks after.
2 weeks after. You have received, it's a criminal appeal conviction matter.
Yes, Lord.
You have received deposition copies.
No, deposition copy.
Yes, yes, I have given. I have given.
Yes, madam, deposition.
All right. The Learned Counsel for the state submits that he has received the deposition copies from the Learned Counsel for the appellant. Stop. The Learned Counsel for the appellant seeks for an adjournment for 2 weeks. Put up this matter, April region.
Item 42.
As to occasion, your lordship directed the state council to take instruction regarding
Local securities.
Aye,
Kudia Loko.
West Bengal.
Verified the surety Sanjay Nayak. Identity is correct. On verified ROR found to be genuine. Criminal antecedent verified. Nothing adverse. Okay. Then Panchanan Nayak verified correct. ROR found to be genuine. No CA. Okay. Address verification is.
Address.
Acha. Quebec kedin roileni?
More than 7 years. Custody since 5/3/2017.
What is the sentence import?
10 years.
20 B2C no?
Yes, ma'am.
Are the Learned Counsel for the petition, Learned Counsel for the state? The Learned Counsel for the petitioner submit that the petitioner has remained in judicial custody for more than 7 years out of 10 years of substantive sentence imposed by the Learned Trial Court. And there is no chance of early hearing of the appeal in the near future. And paper book has not been prepared. Learned Counsel for the state has already obtained instruction about the has made the instruction about the address verification, which is found to be correct. Today he has produced the written instruction received from the IAC Jharpada police station, from which it appears that the two local sureties, namely Sanjay Naik and Panchanan Naik, are genuine bailers, and the ROR was also verified. It was found to be genuine, and there is no criminal antecedents against the bailers. Considering the submission made by the Learned Counsel for the respective parties, the sentence imposed by the Learned Trial Court, the period of sentence already undergone by the petitioner in judicial custody, absence of any chance of early hearing the appeal in the near future, and keeping in view the ratio let down in the case of Muhammad Muslim case. I'm inclined to release the petitioner on bail subject to condition that Sanjay Naik and Panchanan Naik shall be two local sureties for the petitioner. Yes.
Stay relation.
Stay relation.
Oblige.
Item 43.
May I please, Your Lordship? Your Lordship, here the petition.
Item 44.
Yes, Mr. Panda.
4 I have prayed for bail in the
Yes.
criminal appeal.
Huh?
I have been convicted, my lords, under 20B2C of the NDPS Act.
Yes.
And I've been sentenced to RI for 10 years and fine of 1 lakh of rupees.
What period you have remained?
I have remained in custody now till date 1 year and 9.5 months.
So what can be done?
Lords, my submission is that the entire trial is vitiated because the excise officials have no power to prosecute me.
Why?
The Excise Act, there is no notification prepared after the
No,
Excise Act came
that
into
notification was produced, Mr. Panda, in another case.
Which
It
notification?
was produced that they have.
Till date, there is no notification.
Take instruction on that. What is your instruction?
There is some instruction is there, I believe.
Last
Exhibit D.
The produce, you take that instruction. In terms of that section 42, some notification has been made that who are the.
I'm not concerned with 42 millers.
Yes.
42 empowers search and seizure.
Yes, yes.
I say yes, they are authorized to search and seize.
Then what do you say?
But how are they authorized to investigate millers? For investigation, it has to be a notification under 53.
That notification mentions everything. You let him obtain instruction.
Which one, millers?
Let him produce that instruction.
I believe that is on record, flag D.
The Learned Counsel for the.
The notification which your lordship is referring to, that is on record in this appeal at flag D, I believe.
Instruction. Mr. Devasis Panda, Land Counsel for the submits that the investigating officer who investigated the case has no jurisdiction for investigation. Land Counsel for the state seeks some time to obtain instruction on such government, and particularly with reference
the notification which they are referring to is of 1988, when the Bihar and Odisha Excise Act was there.
Exhibit. What is that exhibit?
D.
D.
Flag D.
Flag D. Flag D. This is a letter of Superintendent of Excise Malkangiri. Order number so and so, empowered the officers above as so and so. So you produce those orders, Mr. Those orders. This order number have been mentioned. What is there? We'll see that.
96 dated 4/1/2008.
Right, at all these things. You have got the copy of this D, Mr. Panda?
No, I don't have it.
So hand over a copy. Let a copy of flag D later datum be handed over to the land council. You produce this order number 601 so and so 23/3/88, order number so and so 88, which are empowered so and so. All right. Put up this matter in the week commencing from 27th of March.
Free copy of that.
Yes, free copy of that. You just hand it over, Mr. Panda.
Well, how about the first week of April?
All right, 2nd of April 2024. 028 flag data and hand over for them. 2024. Yes.
Item 45.
Yes, Mr.
45
Tripathi.
Proceed, my lord. Here I pray to sought for instruction from the client itself, my lord, because there is a letter from the client that he wants to change the advocate and engage the counsel from the legal aid.
Where is that? Where is that letter?
That noting itself shows that, my lord, that. And just 2 days back, but 2 days back, my lord, I have talked to that my London friend appearing that Mr. Kormi talked to the brother of the petitioner that he has stated that there no such letter he has written to anywhere below.
Babu, jail no such letter came ଲେଖିବ ନିଜର ଦସ୍ତଖତ ଅଛି jail superintendent ତାକୁ forward କରୁଛନ୍ତି. If you want, we can obtain instruction.
Obtain an instruction to that effect. If you say that, then I have got no objection to that.
The Learned Counsel, Prisoner's Petition at flag C टा कौन सी उड़ा एनु मोर दंडादेश अपील नंबर 100 सरकार के तरफ वकील नियुक्ति करा अच्छा सरकार के तरफ वकील नियुक्ति करा गले कोई छरा तो आपण
I have filed. I was engaged earlier.
तो से अर्थाभागरु वर्तमान आपण so we can engage you as the advocate, but don't charge fees now.
Your lordship, please.
Okay. I'm using him. Okay, but look on. The Peru, the prisoner's petition at flag C, in which it is mentioned that he is unable, in view of his financial difficulty, is unable to engage any counsel, and request has been made for engagement of counsel through legal aid. Mr. Sushant Kumar Tripathi is engaged as the legal aid counsel for the appellant. The intimation be given to the appellant in this respect by the registry through the London Trial Court. You want to move this application today?
Lordship, we should any other. Next week, any demand.
All right. On the request of Mr. Tripathi, the interim application for bail and stay realization of fine be listed in the week commencing from 18th March 2023. The rest of the matter after lunch. We'll do. criminal antecedent, if any, against Okay, non appears adjourn.
Number 56.
May I please, Lordship?
Yes, Tirth Kumar Sahu. All right, none appears. Adjourn. Next.
Item 59.
59, Mr. Pradhan.
I'm appearing for the case.
Yes.
I'm appearing for the case, my lord.
You want to argue or adjournment?
I want to argue.
You argue.
My lord, item number 59, sub item number 2, kindly taken up tomorrow, 15 days.
All right, that matter I am adjourning, but she wants to argue the matter, past matter. Second, that is CRLA number 700 of 2023. The Learning Council for the appellant 6 for an adjournment. It's adjourned. April. Yes, argue the matter.
My lord, the appellant is in custody since 3 years now, from 2021. And he has been convicted for
What is the conviction and what is the sentence imposed?
my lord, conviction is under offense under 20B to subsection 2C.
So 10 years sentence is there.
10 years.
So how many years you are in custody?
3 years, my lord.
So how can it be done?
My lord,
Can be done.
my lord, the appellant was a passenger. In
That whether you are a passenger or you are found in that vehicle, unless 37 is addressed, you cannot get bail, particularly when you are found guilty.
My lord, section 42 has not been complied in
That is a matter to be argued at the appropriate stage.
And also, my lord, section 100 and subsection 4 of CRPC has also not been complied. And
Get after summer vacation. Next. Yes.
my lord, interim bail may be granted.
Sorry, that will be possible after half of the sentence. Yes, next.
Item 60.
60, Sushant Kumar Rao.
My lord, I have taken out 2 weeks after my lord.
Okay, I will. You are in
Item number
CRLA
1, Ravindra Kumar De.
1028.
My lord.
Okay, and 1086, Mr. Amitabh Das is not there. Okay, you place your matter. What is the conviction here?
Conviction 10 years and fine of 1 lakhs. And the petitioner is custody.
Wait. 20B to C oblique 29. And sentence is 10 years, right? 10 years and 1 lakh in default so and so. So any of you are on bail during trial?
No.
So what period you have already on?
8/11/2020. 8/11/2020.
So you have not undergone half of the sentence. 8/11/2020 means even you have just undergone 3 years and some sentence. And moreover, commercial quantity you are to satisfy 37. Sentence is not half of the sentence. So you wait adjourning this matter. Stay of realization of fine allowed for them. In all these cases. 3 cases. No, 2 cases refile. Stay allowed. But 8 after summer vacation. Yes, next.
66.
66, Mr. Mahanti. What is a conviction case?
Conviction.
What is the offense?
Offense 307 and 326.
Just a minute.
Punishment is 14 years.
Wait.
The consecutive.
RI for 6 years, 5,000 under section 326. 8 years, 5,000, 307. Oh, consecutively, that is how 14 years. So is a 320, is it a case of acid?
No, it is a stabbing.
Stabbing. So you are on bail during trial?
During trial, I was on bail.
66 on bail. Who is the that injured?
Injured.
PW?
PW7.
7. And doctor is?
Doctor 14.
PW 14. PW7 is Samsundar Patro.
Samsundar Patro.
The informant so and so. I know the accused so and so. Taking the accused came and stabbed me with a knife in my belly for which this time came. MB hospital 15 days so and so. And doctor is PW 14. PW 14 the working. Working and so on. Yes, about anything against this CA about the CA? Mr.
Not called for, my lord.
Get the case the criminal antecedent. Mr. Srinivas.
Antecedent which
submits that the petitioner was on bail and he has never misutilized his liberty. However, the learned counsel for the state submits that the matter may be taken up. You're a court
Podoga. In Noagar.
Matter may be taken up next week in order to enable him to obtain instruction about this year. Put up this matter on 27th March 2024. All right.
Item 67.
Yes, Mr. Dibedi.
The appellant acquittal dated 26/6/2023.
Is it a conviction case?
Acquittal.
Acquittal.
Challenging.
So
Delay condemnation.
it's all right. Notice has to go, or it has already gone. The accused persons have been, acha, one accused.
Yes, ma'am.
All right. IA number so and so. This is an application for condonation of delay. Issue notice on the question of limitation. Requisites for service of notice by speed post with proof of delivery shall be filed within a period of 1 week.
Right.
Out of this matter, immediately after the notice is made sufficient. Yes, for consideration of the application for condonation of delay. Hala?
Only delay condemnation.
That is to be considered after hearing the other side. You cannot be condoned because state is not the only party. The accused who faced trial, he has been acquitted and you have made him as opposite party number 2. So he has a right to be heard while condoning your delay. Yes.
Item number 71.
May I please, Your Lordship? Lord, I am permitted to
My lord, 6 time, man.
And counsel for the petitioner, appellant 6 for an adjournment. Adjourn, yes.
Item number 75.
May I please, your lordship? My lord, I'm on BC, my lords.
Yes.
My lord, it's a case under section 395. He was convicted, sentenced for 10 years. Today, my lord, I am serving the depositions. Your lordship may call it some other day.
You have received the deposition copy?
My
No.
clerk is there.
All right. The learned counsel for the state has received the copy of deposition from the learned counsel for the appellant and seeks some time to go through the same. 395, you obtain the criminal antecedent instruction about. Anichanji. Criminal antecedent matter. Asini? No, I'm obtained. All right. Learned counsel for the state shall obtain instruction about the criminal antecedent, if any, against the appellant. Put up this matter on 27th March 2024. Report ମଗାଇଥିଲା ଜେଲରୁ କଣ ପାଇଁ ଯୋଉ
ସେଟା ବିକେସ୍ ଉପରେ ମଗାଇଥିଲା ସେଟା
କଣଟା ରିପୋର୍ଟ health condition report. No, that was disposed of. Interim bail ପାଇଁ ମଗାଇଥିଲା, that was disposed. Yes, next. Put up this matter. Yes, the next connected matter is Mr. Prabhu Prashanna Behera. Yes.
Let it come along with that.
Okay, put up this matter along with so and so. Yes.
Yes.
Item number 76.
Mr. Jena.
On behalf of Mr. Jena, Passover.
Passover naik. Next week or do. Yes. Yes. You have received the deposition copy? Item 76, madam. Yes, 76. Yes, CRLA 1305. Madam. Okay. Next week.
Item number 77.
Yes, Mr.